and welcome to Facts or Frauds. Now it's time we get down to trial for Jahmal and Steven Perez.
What you are witnessing is real. The participants are not actors.
The Commonwealth of Massachusetts versus Jahmal Latimer, a.k.a. Jahmal Bay, and Commonwealth of Massachusetts versus Steven Perez, a.k.a. U.S.A. L4 and docket numbers are 2181 CR 00361 and 2881 CR 00366, and ask parties to identify yourself for record, starting with the Commonwealth.
Good afternoon, Your Honor. Graham Van Epps for the Commonwealth.
Ryan Rawl, also for the Commonwealth.
Good afternoon. ADA is Van Epps and Rawl.
Good afternoon, Your Honor. Daniel Thompson for Jahmal Latimer of Dula Bay. I did recognize his voice when the clerk checked the audio on the Zoom.
Good afternoon, Your Honor. Josina Reisler-Cohn for Mr. Lucha L. for Libertad, who is hopefully also on the Zoom from Billerica.
Okay. Good afternoon, Attorneys Thompson and Reisler-Cohn. Trying to do a sort of a triage approach, I'm told that Mr. Lucha L, we may lose him at 3 o'clock because of staffing issues at the jail. So before that happens, I want to try to figure out whether we can proceed in his absence if he has to leave the call, or whether, in effect, we have 10 minutes. Attorney Reisler-Cohn, you may not have had a chance to discuss this with your client.
I haven't, Your Honor. I was able to speak to him prior to the hearing, but I haven't discussed with him if he's amenable with the hearing proceeding in his absence. I'm happy to perhaps whoever is with him from the sheriff's department could facilitate a quick phone call.
I think that actually turns out to be a good idea because, under Murphy's Law, we have a verdict. So in the case that the jury is deliberating under. So what I think we'll have to do is take that verdict. That will give you, Ms. Reisler-Cohn, I hope we can set up a call between you and Mr. Lucha L to figure out whether after we take the verdict, you're able to proceed, or whether we have to adjust our schedules in some fashion.
Sure.
And while we're taking the verdict, I want to prioritize getting your feedback on the juror questionnaire and the impanelment script, so that hopefully we could go ahead with impanelment, even if we have some outstanding motions eliminated that have to be shoehorned in around an impanelment. So if we can proceed without Mr. Lucha L, I want to do that when we come back. If we can't, I think we're going to have to, when we come back, we're going to have to talk about how to approach scheduling and impanelment. All right, thank you. Okay, let's start with Ms. Reisler-Cohn. And by the way, Reisler-Cohn?
Yes,
Reisler-Cohn. Please, I know it's, if you don't mind correcting me if I get it wrong, I don't like to mispronounce people's name, but I do it with alarming frequency. So please don't hesitate to just say Reisler, so I get in the habit of getting it right. And that applies to everybody if I make mistakes. Let's start with you and ask, where do things stand with respect to Mr. Lucha L and his, I gather he can't be with us anymore on Zoom today.
I understand from the clerk that they removed him from the Zoom room, so he's not on Zoom anymore. I did have an opportunity to speak with him. He is comfortable with us going forward as to discussing the juror questionnaire and issues around impanelment and voir dire. Any other substantive issues he would want to be present for.
That sounds perfectly reasonable to me, and please let him know that his willingness to allow us to do those matters is appreciated. So that means we won't do the Telegram text messages today. That's substantive. We'll have to sort of shoehorn that in around. The good news is, it seemed to me, I reviewed the text again carefully in Ms. Reisler-Cohn's objections, and Mr. Thompson, I gather, joins in them. Maybe I've got that wrong, but in any event, those are the only objections I have. And it does appear to me that they are focused in such a way that the hearing itself is unlikely to take a long time. It seems like a pretty manageable hearing. And Ms. Reyes-O'Connor, I appreciate your laying them out in a way that I can follow them that is concise. So whenever we find some downtime, we can do that work. Are there any other motions in limine outstanding? Obviously, we're not going to discuss them now, but I just want to know if they're out there that we have to still address.
There are a few lingering issues from Monday. There's the my motion in lim to exclude a few bits and pieces of body cam video that I think were deferred maybe to be able to play those videos and have some more discussion. We can't do that
today. We can't do that one today.
Right.
Right.
And then Your Honor had raised a question related to the Commonwealth's ability to impeach Mr. Lucha L if he were to testify. Right. And so there's some follow-up around that. I think that is it in addition to the Telegram chat.
I'm sorry, Mr.
I understood those were going to be issues that we dealt with during the trial as evidence is offered. But
it certainly may play out that way. I think we can kind of I just want to keep them in mind as what's pending.
Right.
The issue about doing them as they come up is that to the extent they require editing by the Commonwealth, I know the District Attorney's Office staff benefits from having a day or two's heads up to actually do the physical editing, but it's a moot point for today anyway because we are where we are. All right, so let's first talk about the juror questionnaire. I did get the list of witnesses that I think Mr. Van Epp sent. Does the defense agree that that's a comprehensive list of witnesses?
Yes.
I thought that Von Alcaraz was considered. Oh, from the names that maybe mentioned. Right. Is it at the bottom? Oh, you know what? This came off our pre-trial, so he was at the time listed as a defendant. We should have Mr. Aaron Jimenez, Von Alcaraz.
Okay.
The name that may be mentioned.
All right. Let me bear with me for just a moment. I'm going to open up my digital version of it because that's the easiest thing. The one question I had is, are both parties content with listing the other co-defendants as people who may be mentioned, meaning that we are not listing them as witnesses? Obviously, the likelihood that any of them would actually testify as witnesses in this case is vanishingly small. Yeah. And it sounds like neither party is planning to try to call them. But are the parties comfortable with listing them as people who may be mentioned?
I am, and they will be mentioned because they will either be.
No, I have no doubt they'll be mentioned. I just want to make sure that no one is concerned about not listing them as potential witnesses. I mean,
I'm not concerned. I'm fine with them being listed as other names which may be mentioned.
All right. So it's Mr. Alcaraz's name is
Aaron.
Aaron.
Yep, and last name is Jimenez.
Yeah.
And also known as it's spelled A-B-A-N.
A-N?
Aban is A-B-A-N. Then L, Currah is C-U-R-R-A-G-H, I believe.
Okay. All right, I've added him.
There's a sergeant that didn't make it on that list. He's a state police sergeant, Matthew Simpson. He was involved in transporting and booking not these defendants, but one of the co-defendants. But he should be on the list. Matthew Simpson.
Matthew Simpson. All right. And he's a sergeant?
Yes, he's a state police sergeant. I'm sorry, lieutenant. He's a state police lieutenant. Excuse me.
Okay, a lieutenant. Now, what I noticed on the list too is I didn't see on the list any witnesses, it's certainly possible that some of the witnesses on that list are witnesses that the defendant may call, law enforcement officers, but on the list of actual witnesses to be called, I saw only law enforcement officers. So I just want to verify there are no civilian witnesses that the defense may call.
Correct for Mr. Abdullah.
And also correct for Lieutenant.
Okay, that's fine. Let's talk about the questionnaire itself. Why don't we start with the defense as far as revisions that you think are necessary?
So speak for Mr. Abdullah. I asked in my motion for examination of jurors for the following questions. The answer number 9, would you hold it against any of the defendants if any of them chose not to testify? In your Honor's questions, mostly around item number 13, going over from page 4 to page 5. You do hit on some of the other things I asked about defendant not testifying, but I would ask that you ask the question, would you hold it against the defendant if he did not testify?
I meant to include that. I must have edited by accident. So, would you hold it against either defendant if they did not testify? I will ask that question.
Then, throughout, presumption of innocence to Mr. Messiah.
Oh, I'll do a check on that. I'll edit for that. Thank you.
The next one is item number 18 at the bottom of page 5. So it looks like this is based in part on my question, relationship to March for Our Lives, etc.
Yep.
Your Honor added American Rifle.
I meant to add the National Rifle Association, which I just changed, but yeah, it should be the National Rifle Association.
So I did not ask for National Rifle Association, but I have no problem with that being put in there.
I knew you didn't ask for it, but I kind of felt if I were going to ask about anti-gun organizations, that it's only fair to the Commonwealth to ask if you belong to a pro-gun organization, and that was the only one I could really think of. So
I'm fine with that. The next one is item number 24 on page 6 in the middle.
Yeah.
So I don't know how much Mr. AstaraelDarkrahBlack disagrees with Mr. Abdullah on this, but Mr. Abdullah, in terms of, I don't know if I'm butchering the difference between, race, creed, and national origin, but he prefers to be identified as Moroccan American.
Okay. Let me start by asking, what's Mr. Lucha L's position on that?
Well, this question is really not aiming to get at bias the jury might have about the defendants in front of them's race or national origin, but is more based on what I expect they're going to hear during the trial.
That's what I was thinking too, is that this isn't necessarily saying that any one defendant identifies now as a member of the Moorish nation, but rather that they may hear evidence that some of them, at least at the time of their arrest, identified in that way. And I think that somebody identifies as Moroccan American is I'm trying to think. I'm looking to see if there are any. There's a question about Muslim men, but I don't have too much of a sense that there's any anti-Moroccan bias that's separate from potentially anti-Islamic bias.
Well, the original kernel from that question didn't come from Mr. Abdullah. I think it was Mr. AstaraelDarkrahBlack's question.
Right, but I guess what I'm saying is that I gather there is going to be evidence that some of them identified as members of Moorish nation. Is that not right?
Well, the chat comes in titled the Moorish Militia Committee. There's discussions about them being Moors, you know, in various chats. There's the conversation that even Perez or Lucha, El Pueblo Libertad, wants to exclude, where Mr. Latimer is talking with somebody on the phone named Maurice, who was holding himself out to a state police officer on the phone as being a consular officer of the Empire of Morocco, which he makes clear is different from the Kingdom of Morocco.
All right, but we can't cover all the various terms.
What I'm just saying is, I don't know how the defense intends to use this evidence or not. I don't know that in booking, for example, there's going to be any discussion about any defendants identifying as being Moroccan American, or anything other than the names that they're booked. So it's unclear to me what this question is designed to ferret out here.
Well, I think it's designed to ferret out people who, upon hearing some of the evidence that you are seeking to introduce, like I can't give a comprehensive list. Here are all the identifications that you may hear during this trial, Moroccan nation, this kind of thing. But to try to get at, do you have a bias against somebody who identifies as a Moor or a Moroccan, I suppose? I wouldn't mind adding, you will hear evidence in this case that some of the defendants identify as members of the Moorish nation or as Moroccan Americans. If that...
And just to be clear, the defendant and the website he ran, it's called the RiseOfTheMoors, there is a movement in the country of like the Moorish America.
But I'm not interested. I'm not interested in this trial at exploring all the types of groups that may identify as having some connection to the historic Moorish people or Moroccan people. It's well outside the scope of this trial. I recognize that how people identify can be very important to their sense of identity, and that they may want to identify in that way in some sense in this trial, and that's fine. I'm just trying to get at a question that captures bias against, I mean...
Maybe the way to do it is to say, if you heard evidence that the defendants identified as being Moroccan or Moorish, you know, does any of that have any special meaning for you?
Well,
some people may not know what Moors are, and some people, frankly, they may hear that and say, none of this matters to me.
Right. I wanted to include something about the Moorish nation because there are a variety of sort of nationalist movements all across a huge number of nationalist movements. And I think there may be jurors who, if they heard Moorish or Moroccan, would say, no, that doesn't mean anything to me. I mean, I don't, you know, but if they hear Moorish nation, I mean, like, that sounds nefarious to me. That sounds suspect or somehow, you know, left wing or right wing or whatever wing. So I want to capture that. I'm inclined to say, let me hear what Mr. Lucha L says. You will hear evidence in this case that some of the defendants identify as members of the Moorish nation or as Moroccan American. Have you heard of these groups? Well, that's sort of difficult to say. I think maybe just distill this into one question. You will hear evidence in this case that some of the defendants identify as members of the Moorish nation or as Moroccan Americans. Is there anything about a defendant's, about these identifications that would affect your ability to be fair and impartial juror in this case?
I think I like it as two questions, and the reason is because Moorish nation is many people may not have heard of it. If somebody has heard of it, maybe they've heard of this case. Like, I mean, it's such a nuanced thing that I think if somebody does know about it and is familiar with it, we need some follow-up.
How about this? You will hear evidence in this case that some of the defendants identify as members of the Moorish nation or as Moroccan Americans. Have you heard of the Moorish nation before?
I think that's fine.
And then the next question, is there anything about a defendant's membership in the Moorish nation or his identification as a Moroccan American it would affect your ability to be fair and impartial.
That works on our end.
Commonwealth? Commonwealth?
Commonwealth has tried very hard to make this case about possession of firearms and not the ideologies. I appreciate that we're trying to suss out bias here. I don't think this question is necessary. But
I disagree with that. I mean, the case is clearly, as a matter of law, is about unlawful possession of firearms, ammunition, body armor, that kind of thing. But the jury that we pick we have to be confident is going to view it that way. And if somebody has a bias against the Moorish nation or the self-identification of Moor or Moroccan American and can't therefore separate that from their evaluation of the evidence, then we've defeated the purpose. So I guess what I'm saying is you may very well be right as a matter of law, but we need to find a jury that can follow that law. So I am going to ask those two questions as modified. Next question, Mr. Thompson.
That's all I have.
Mr. Raisler-Cohn.
So there is a question in the questionnaire about police credibility. I did also request the question, do you think that police officers always tell the truth? I would suggest that be added to the questionnaire.
I'm not going to ask that question. I really have yet to meet anyone who would answer yes to that question. I've never seen it. I've never seen anybody who would say they always tell the truth. I think somebody who believes that the police officers always tell the truth would answer yes to question 14. Right? In other words, unless they also believe that civilians always tell the truth, meaning that they can't, everybody always tells the truth, so I wouldn't be tend to believe one over the other. That I think is purely hypothetical. So I'm not going to ask. I don't like to raise possibilities that I myself view as absurd, which is that anyone thinks that police officers always tell the truth. I do think there are plenty of people who think police officers are more likely to tell the truth on average than civilian witnesses, and that's why we ask these questions, but I'm not going to ask that.
That's really the only thing I wanted to mention, other than reminding myself when we talked about after the jury completes the questionnaire, I just want to make sure I understand if there's a question I had put in my proposed voir dire questions, it's not in the questionnaire.
You may ask it on, yes, you may. I didn't see any questions that you listed that I think would be improper for individual voir dire. They're not questions I think belong on a questionnaire, but the reason for that is I try to keep the questionnaire, I mean, I may or may not have succeeded in this case, but I try to keep it short enough that they don't lose focus and start just answering questions, sort of carelessly, that they actually focus on the entire questionnaire. So it's sort of a desire to be comprehensive without being so long that you get bad responses. Just to go over the procedure, and I will hear from the Commonwealth on the questionnaire, but since it's in my mind, what I do is they fill out the questionnaire. Once they're all filled out, they're brought back to Ms. Noble. Ms. Noble starts flagging questions that require follow-up. I take it you all understand what that means. Like, are you aware of any bias? Yes requires follow-up, no doesn't require follow-up. I then get them one by one as the jurors come in, and what I do is I read off to the parties, these are the questions on the questionnaire that require follow-up. You'll have obviously one there so you can see what those questions are. I don't make copies for the attorneys just out of concern for the environment. It's a ton of copies. It also slows things down. But if at any point any counsel wishes to see a particular questionnaire, either because you're confused about the questions I'm reading off or you just want to sort of spot check that we're catching all the right ones for whatever reason, just let me and Ms. Noble know, and you can take as much time as you need to look over individual questionnaires. Then I go through the questions that require follow-up. I won't go through my whole process, but I usually start with a hardship question, because if there's a legitimate hardship, there's no point in discussing any of the other things, and we can move quickly along. And then I try to go sort of in order of how likely the question is to exclude the jury. So whatever most likely it is to exclude the juror, I'll go to that next. And I ask follow-up on all the questions that require follow-up. And then I generally, if I'm going to excuse somebody for cause or for hardship, I check with the attorneys to see if there's any objection. I always do. And if there's no objection, then I'm sorry. Well, after I do the follow-up questions, I turn to the attorneys for their follow-up questions. And you have 3 minutes and 1.5 minutes each. But again, I'm not going to stop you if you're getting at something. Once you've had a chance, occasionally I will ask a follow-up based on your follow-up, not usually, but every so often. And then I'll either excuse the jury after consulting with you or the juror, or I will declare the juror preliminarily indifferent, and I'll look to whoever was questioning first for challenge for cause, then the other side, and then peremptory challenge, and then the other side, and I switch from, and as far as the defense goes, if you want to switch each time and, you know, one of you go first and then the next one go first, I'm just going to say defense, and I'll leave it up to you how to allocate your order. Okay. All right. Commonwealth on the substance of the questionnaire.
I have nothing further on it, Judge.
Okay. Fine. All right. So we've got the questionnaire. I'll edit it. I'll try to get the final draft out to both sides. I don't require a follow-up, but if you want to follow up, if you spot anything that, wait a minute, Judge, you said you were going to do this and you didn't, please feel free to bring it to my attention, of course. How about the impanelment script?
You had a question, Your Honor. I think looks like page 2. Looks like you had a comment. Some of the defendants were carrying loaded large capacity semi-automatic rifles, and I saw a note that you had a question about that.
Yes, I was trying to understand if both Mr. Latimer Abdullah Bey and Mr. Perez Lucha L are alleged to have carried weapons. I just couldn't remember.
So Mr. Latimer definitely, it's on the video throughout. Mr. Perez, in terms of handling weapons, there's a moment where he handles Mr. Latimer's weapon. There's also, he appears to have some kind of rifle or something slung over his shoulder when he's talking to Mr. Latimer, but you can't identify what it is. So, and he discusses the firearms with Mr. Latimer, if that gives any information to the court, if that answers the court's question.
So I'm trying here, there weren't large areas of disagreement on the statement of the case we read to the jury, but there were some. And it occurred to me, both defendants were dressed in camouflage clothing and wearing body armor, I think, is my recollection from looking back at my notes. But I was trying to figure out what to do since we have only 2 defendants. I was a little concerned about saying some of the defendants because from the juror's point of view, there's only 2, even though they might perceive that the others were charged separately. We're not going there.
I mean, one thing that the way the court addresses is refer to Mr. Latimer by name and other individuals present with him. Just leave it at that.
Are the attorneys content with that formulation?
That's fine with me.
I would just say, where it's not clearly referencing Mr. Abdullah Bey and Mr. Lucha L, to just say the suspects.
Well, but that suspects that creates confusion, I think. I could see a jury saying, or a potential juror saying, who are the suspects? Are they these 2? Are they others? What if I say, right now I have trooper encountered the defendants, which is a little confusing because are we talking about these 2 defendants or other people too? So what if I said the indictment's alleged on such and such a date, a Massachusetts police trooper encountered a group of men just after 1 a.m.
That's fine.
The men were dressed in camouflage clothing and wearing body armor. And then say some of the men were carrying loaded large capacity semi-automatic rifles. Is the Commonwealth content with that?
Sorry, I'm just looking at the rest of the language here.
Yeah, I may have to adjust some more language after that.
I mean, if the court's going to refer to the group as the men or the individuals, I think it just needs to be made clear that the Commonwealth is alleging that the two defendants here in this courtroom were part of that group.
Right, and I don't think that will be any. I don't think the jury is likely to be confused about that fact, since they are the two people sitting here.
But as long as that's clear, I think the court's proposal is fine.
And then you can go to the indictments further allege that the defendants, with other men wearing similar camouflage outfits and body armor, were standing near two vehicles, because that's not confusing. And then the indictments allege that after the defendants refused police instruction, I guess we should go back to the men there, because it's alleged that all of them, one way or the other, refused. And then at the end, I could say that the indictments further allege that neither of the defendants nor their companions had a license to carry firearms. All right, I think that takes care of it.
There's one other factual correction to be made.
Yes.
In the original, it was at the bottom of page 2. It just needs to be made clear that I believe only Mr. Latimer or Mr. Abdullah Bey is charged with a false name, giving a false name. I believe Mr. Perez is not.
That's correct. I was going to bring that up too.
Okay, let me see here. Where are we?
So, the bottom of page 2, which lists out the charges and goes on to the top of page 3,
okay.
And giving police a false name following in arrest. So that is just as to Mr. Abdullah Bey.
All right. Okay, so they're charged with possession, all that. And then I'll stop at possession of ammunition and say, additionally, Mr. And I can't remember, am I already into calling them just by their, yeah. Okay, so Mr. Abdullah Bey is charged with giving police a false name. So they've both been charged with all these offenses up to and unlawful possession of ammunition. Additionally, Mr. Abdullah Bey is charged with giving police a false name following an arrest. Does that address? All right. Anything else that either party wishes to raise on this?
No, Your Honor.
Okay. So we were just talking about kind of the semantics of defendants and men.
Yep.
This uses the word companions a number of times, and also at one point uses the word associates.
Can you point me to where?
During that time, 2 of the defendants' companions were arrested approximately 1/2 mile away. So in my suggestion, which I think the Commonwealth and I did have an agreed to statement, but maybe I misremember that.
Not in the final pretrial memo. In the final pretrial memo, which is what I was referred to on Monday, there's the Commonwealth version, and then there's your version in which Mr. Thompson joined. And they're very similar, but not identical.
I thought there was something that Attorney Rachel Cohen filed with Judge Frenier back in.
All right, well, if so, I don't.
In any event.
Not before me.
So what I had proposed was that it would say during that time, 2 of the other men present were arrested approximately 1/2 mile away.
Commonwealth, is that satisfactory to you?
What did
So instead of during that time, 2 of the defendant's companions were arrested approximately 1/2 mile away, it says during that time, 2 of the other men present were arrested. All right, I made that change.
And then similarly, 2 sentences from there, it says, after the defendants and their companions eventually surrendered. Again, I would suggest after the defendants and the other men.
Any objection to that, Commonwealth?
No, Your Honor.
Okay, so I made that change too.
And then there's one more, I think it's the last sentence of that paragraph. The indictments further allege that none of the defendants or their companions.
It now says the indictments further allege that neither of the defendants nor the other men present.
Oh, right, we already addressed that.
No, so I'm just changing companions to the other men present, Commonwealth.
That's acceptable to the Commonwealth.
Okay. Anything else from either side?
On page 4, there's a reference to Mr. Massey as well from the
Counsel section.
Yep, it's just before the trial schedule and length heading.
Not seeing that. Oh, from Mr. Massey. Well, I wouldn't make, since I don't give this to the jurors, I only read it, I would catch it, but thank you. So, so for the defendants, it'll say. Thank you.
The only other thing I was going to mention, which, you know, of course, the court will make the right decision about this, just in terms of timing, where it says, you know, could last through Thursday, June 13th, or even into the beginning of the following week. I just highlighted that into the beginning of the following week because of, you know, my fear of how many people we may lose. I know we had discussed the schedule.
I will tell you, I am a firm believer. I'd rather lose a few people that we didn't need to lose because they have some travel plans in that following week where we don't think we're going to get to, than I would to seat those people because we didn't tell them it was going to go that long. They said, you told me it was, like I didn't bring up my travel schedule because you said it was going to end by then. So I'd always rather expand it out. And what usually happens is that people say, well, I have travel like the week after that. And I'm like, you're fine. We're not, you know, and then it's been fully vetted.
Okay. Yeah, nothing else for me.
Okay. I do want to ask the parties' input into an issue. I'm putting together my pre-charge in combination with my final instructions, which are just at the beginning stages. I think I have two options on the pre-charge. One is not to tell them any elements of any offenses, just to tell them these are the offenses. Or to give them the elements of the lead offense, that is possession of a large capacity firearm without a license to carry or FID card. And then say as to the other charges, there are sort of other similar elements, but I'm gonna hold off. There's no way I think it makes sense to instruct them on all the elements of all the offenses in a pre-charge. So I guess I'd like to know from both sides if you have a preference as to whether I charge on the whether I give them the elements of the lead offense or simply, I'm inclined not to do any instruction at all because the elements of the offenses are not exceptionally complex. There are aspects of them that may be a little complex, perhaps, but in general, it's possessing a firearm, a high-capacity firearm without a license or FID card is fairly comprehensible to most jurors. So, but I'm interested in if anybody has a strong opinion one way or the other.
I think if you were to instruct on the elements of the 10M offense, a large capacity, I think that would be fine. If there's going to be a pre-charge based on the nature of the case, I think some preview of the general concept of joint venture or aiding and abetting, I think it would be wise to include that because you're giving them a preview of the elements. I think it's fair that they get a preview of how it works when there's multiple involved parties. And I'm not saying that to be a full-blown Zanetti charge, but I think...
I understand. I generally wouldn't give a full-blown, but it's sort of a preview defense from that point. On either issue, do I instruct on the lead charge, the elements of the lead charge? Should I instruct on joint venture?
I would, of course, at least give the instruction on for Mr. Abdullah, the possession of a large capacity weapon.
10M.
So he has two 10Ms, he has a large capacity weapon and then the feeding device.
Right.
But at least as to the large capacity weapon, I have a strong opinion about.
So you agree with the Commonwealth that I'm now hearing from the Commonwealth and Mr. Abdullah Bey, yes, give them the elements of 10M so they at least are thinking about generally how elements work. And you don't have a strong feeling about joint venture?
Right. And to the extent I mentioned elements in my opening, at least the jurors would know what elements are.
I totally understand why one side and or the other might want it. I just want to hear your thoughts before I make a decision. Ms. Reyes-Lacone?
I also agree that it would be helpful to do the 10M instruction. I disagree that it would be helpful to do the joint venture portion, essentially because I think it does get very complicated, and I think we're going to see at the end of trial if, in fact, there is evidence of the joint venture, but I understand if the court feels it is important to give a preview at this point.
I can see the argument for giving a very scaled down joint venture instruction because it seems to me the Commonwealth is going to argue probably fairly strenuously and broadly that this is a joint venture and that therefore there's liability as for aiding and abetting as well as principal liability. And to the extent that I can also anticipate a defense that leads with some notion of guilt by association, or just because somebody's in a group of people doesn't mean that they have any kind of, that they have the same criminal intent as everybody else, which I could imagine. I think it will be helpful for the jury. I do agree with Mr. Vance. It would be helpful for the jury to understand the law that, at least in broad strokes, the law that governs those arguments, so that they can at least have heard of it when they're assessing. I imagine this may come up in openings. And certainly it's going to start coming up, I would guess, in cross-examination in a hurry. So I'm inclined I will instruct on 10M since all parties agree I should. And then I think I will give a very sort of, 10,000 foot view of joint venture. I'm not going to get into the weeds on it because I want to see where the evidence goes, but I will give the notion that if you make certain findings, you may, but are not required to find that people are acting in concert. It's this sort of a headline of Zanetti kind of instruction. And I'll be able to give it to you ahead of time so you can critique it.
Okay. So I just want to make sure I'm clear in my own head that when we're having our charge conference at the end of the trial, as opposed to like what the elements are on 10M, assuming that hasn't been required out that the jury is going to get, that's going to be a discussion and Your Honor is going to make a ruling on whether it's appropriate to give the aiding and abetting instruction at that time.
Well, here's what I'll say. If the evidence that's presented by the close of the Commonwealth's case, for example, doesn't support an inference of joint venture for aiding and abetting, then I wouldn't give that instruction. If the evidence, viewed in the light most favorable to the Commonwealth, could support an inference, the jury could find beyond a reasonable doubt that there was a joint venture, I would give the instruction. What the exact content of the instruction would be, I suppose, is up for discussion, given what the evidence is. But that's why you should review my pre-charge to make sure that there's nothing. I mean, I don't think the pre-charge is going to be specific enough that you're likely to be able to sort of say, you shouldn't say this, you shouldn't say this, because we don't know what the evidence is going to be. But I guess to the extent you're asking, is the pre-charge binding? Like once I instruct on it, that's a finding that there's going to be a joint venture instruction? No. If the evidence doesn't support it, they won't hear about it. But given that it's practically a little difficult for me to imagine, I mean, the Collins case would have to be very different from what they've outlined so far for me to see that that's likely, which doesn't mean that you can't.
You answer the question perfectly.
All right.
Thank you.
Just so it's clear. But I do encourage you to look at the pre-charge carefully, especially the case-specific part. I mean, the other stuff is kind of boilerplate, and you hear it in every case, and but look at the case-specific things carefully, so that if you feel like I've gone too far, for example, with a joint venture instruction, you can say, like, Judge, this is too specific for this stage of the case. I'll listen to you on that. Or you misstated the law, which of course I will listen to you on that too. All right? Okay.
And can I ask one more question?
That's what we're here for.
Are there anything specific in the pre-charge related to like the nature of evidence in a co-defendant trial? I mean, so far I know nothing has come up yet that is being admitted as to one defendant and not as to any other. I generally don't go into that level of detail because I don't think they can follow it. They've never met, most of them have never seen a trial before. They don't understand single defendant versus co-defendant. What I think is the proper approach to that is that the first time that happens in a trial, I think I'm required to give a contemporaneous instruction that explains this evidence has been introduced against Mr. Lucia L., but it is not, you may not consider it in evaluating the case of Mr. Abdullah Bey, or, language to that effect, or vice versa. Give the contemporaneous instruction and then repeat the instruction in the final instruction. But I try to look at it from the juror's point of view. There's only so much they can take in, and I think the pre-charge as we give it now runs the risk of being too much information, that it's hard for them to process. So I don't want to add things unless it's obvious to me that it's something they ought to know, which is the category I put joint venture in this case.
that there is a broad principle, but no, I don't think so.
Okay.
I would encourage you, obviously, to remind me if evidence is introduced against Mr. Abdullah Bey, but not against your client, for example, that I should give that instruction. And I think it's sometimes successful to give it more than once, or to give it each time. You can give it less. You can say, as I've told you before, this is one of those situations where. But I'm perfectly content to give that instruction every time the issue comes up.
Okay. Thank you.
Anything else?
Not on the jury selection.
Okay. Anything else on anything?
No, I just wanted to make a quick record, Judge. I filed discovery notice 11 this afternoon with the clerk. I gave copies to counsel. In that is just a very quick summary of the McFarlane inquiry we've done for all the law enforcement witnesses. I've given copies of that information to counsel, and we'll supplement it should anything else come up. I think some of the information was already known to counsel, but I have a copy for the court if the court wants to look at it. I would ask that it not be filed, but
I don't need to look at it unless and until an issue is raised with respect to it, but I appreciate your letting me know that it's out there, that the issue is there.
the discovery notice it really kind of listed all the things that have come up in various emails that we've sent back and forth and just haven't been, documented in the file anywhere.
It sounds prudent of you to do. Anything else from anybody's side? Okay, so I ask you to be here by 9 tomorrow. It's rare that we actually have jurors ready at 9, but if you can be here for sure by 9. If you need it, see me for anything before we bring jurors up, let Ms. Noble know. Of course, I'll come out. Otherwise, we'll plan to get started as soon as we have jurors.
Excellent. Thank you.
Do you think this show is educational? Yes, it'll drive people to read books.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications, and leave a comment in the comment section. Tell me what you think. And a huge thank you to all of our Facts or Frauds channel members. Wanishi, thank you. If you'd like to become a member, click on the link in the description, or click join right next to subscribe. Now, if you're still hanging out, thank you. I appreciate you all. Hit the thumbs up button, make sure you're subscribed, ring the bell, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.